Corporate fraud works best in the shadows, behind corporate walls. How does the government bring these wrongdoers to justice? Whistleblowers. These are the stories of those who risk their careers to shine a light on allegations of fraud. Today on Fraud in America.
All right, welcome to today's episode of Fraud in America. We have one of my good friends, Director of Legal Education at the Anti-Fraud Coalition, Jacklyn DeMar. Jackie, thanks for joining us.
Thanks for having me. I'm excited.
So Jackie's been on our show before for our longtime viewers, longtime listeners. She's one of the all-time favorites. We brought her back. There's a lot happening in our world right now, and nobody has her finger on the pulse better than Jackie. It's been interesting, Jackie. We are in the middle of conference season. You've been to a lot of conferences. I've been to a lot of conferences. We've held our own conference. So kind of listening in on what's happening in the legal landscape when it comes to the fraud landscape. You have any trends you've noticed? You've been to a recent healthcare conference, you went to a banking conference. Any kind of trends you've noticed?
I think there's definitely still this big focus on cybersecurity and crypto fraud. And I cannot say that I can wrap my head completely around crypto fraud, but I know that people are very interested in it. There's a big push in enforcement in that area. And so there's been a lot of chatter about enforcement around crypto, as well as cybersecurity and the kind of impact that can have in compliance departments in healthcare, but also in other kinds of in other kinds of fields. So your cybersecurity has to be a certain way, and you have to make certain disclosures to the government about your level of cybersecurity protections in defense contracts, for instance, but also, to protect patient information under HIPAA and things like that. So I think there's those two areas of focus are still very prevalent right now. There's also been a lot of discussion. We're about a year out from the super value decision in the Supreme Court. So people have been really focused on kind of what that looks like now and if that's really changed practices. I'd say for us, for the relator side, our practice hasn't really changed from what it was before. We're still pleading the same things because the law, as we see it, was always the same. There was always these three different knowledge standards, and there wasn't some big sea change that had occurred. If the Supreme Court would have gone the other way and held that subjective intent was not relevant, then we might have had to start figuring out how to plead our cases anew and how to prove those up. But that seems not to be the case. And so I think it's interesting hearing from defense side because they still are trying to salvage this decision as something that's good for them. And so they're kind of trying to turn this three knowledge standards into now there's just an actual knowledge standard. And so subjective intent is the only thing you focus on rather than reckless disregard, et cetera. I don't think that's flying anywhere, but that's their argument for now. I think I've also seen this is more of a general thing. But as I've attended kind of more like legal focused conferences versus more compliance focused, the audiences are really interesting and different. It seems like if it's more of a legal audience, there's a lot more people on the defense side that are a little bit more like push back a little bit more on what I'm saying and what other relators counsel are saying, and it's a little bit more animosity. And then when I talk to compliance people, it's really interesting because I think they're genuinely trying to understand what to do correctly within their compliance departments. And so they're really receptive to the kinds of things that we're saying. And they ask a lot of questions. And it's really kind of heartening to see that they're out there, they're internal at these companies, and they do want to do the right thing. So they're really trying to learn. And then there's one other thing that I've noticed, which is questions from defense counsel in the audience about litigation funding. They're really trying to make litigation funding happen. And I've just had to push back and say, look, it's not going to happen. This is not going to be a big deal. But it's like rearing its head again. This concept of a private funder that's coming in to help out either your whistleblower client or you on a particular case in the 10 years it can take to litigate these cases while you're not getting paid and your client is potentially not getting paid. But the government's still asking about that, but there's been no real pushback from the government on it. And I think it's just not going to be a thing that's going to be too big of a deal, but it's still getting asked about.
That's really interesting. This litigation funding issue has always been interesting to me because, to hear the defendants raise questions about funding because they're somehow concerned about funders shifting the priorities of a case seems a little disingenuous, right? If you cut off the funding of a qui tam case, then you can kill the case. So that might be their interest, but it is interesting to see that issue surfaces in weird corners of our world. I love your point about the compliance officers being on our side. It seems like a natural, right, that they should be a part of the anti-fraud coalition in a broad sense, that they are actually on the front lines of identifying fraud before it mushrooms into these qui tam cases or into fraud matters more generally, right?
Yeah, absolutely. And we try to, explain that to them, right? We're on your side. We want to help you do the right thing internally. And so I think that resonates with them.
So we had our own conference recently. Over 300 people came to DC, the leading government attorneys, qui tam attorneys. We had some whistleblowers in the audience. What was your experience there?
Well, I mean, as far as kind of a broader overview, I just noticed that there were a lot more young lawyers that are attending, a lot more first and second time at the conference, attorneys, more sophisticated young lawyers that are coming into this space. I think that is a very good trend to watch. And the more we can educate younger lawyers on the importance of these laws and how interesting the cases are and how interesting the practice is, I think the better. I think we also saw paralegals, for instance, showing up to the conference and learning. And I thought that was so great to kind of bring them into the educational fold, because honestly, having a good paralegal that understands this information can be invaluable. And so I think that I'm loving the kind of expansion into that kind of realm as well. As far as content goes, I think there's a big focus on financial frauds, and we have our own financial frauds conference. But even at this one, we had a few panels on financial fraud type of issues, and those were very well attended. I think people got a lot out of them. And so I think that's going to continue to be a focus for all of us. One thing in the healthcare world that's really expanding is this idea of Medicare Part C fraud. And so there's a huge focus for us on Part C being kind of front and center in the healthcare fraud world right now. People are trying to understand it, trying to understand the damages involved. And so I think that there's a big focus there, obviously now. We've also seen kind of expanded discussions around retaliation. I think there's, everyone understands that the practices in the False Claims Act space. Oh, there's, this Section H part of the False Claims Act that protects whistleblowers from retaliation. But there's also all these other laws, including the financial frauds whistleblower programs, that have protection for whistleblowers. And so I think that there's a desire to learn more about kind of all the things that you can plead on behalf of your clients that could potentially protect them from retaliation. I also thought, like, in the past, I've heard from members that, oh, we're not really interested in like hearing war stories. We want different kinds of content. But I had a panel specifically on war stories from this recent Fessemeyer successful trial, and everybody loved it. It was a great panel. I thought it was so interesting. There's nothing like hearing from the internal people that are conducting these trials about their experience and kind of what they have gone through, what their strategies were. I actually was speaking at a compliance conference after that panel, and I relayed some of the stuff that they had told me, because we were talking about kind of what's the relator's role during trial, if any. And they had an interesting take because they actually decided not to put their client on the stand because there was various issues around it. And like hearing strategies about stuff like that is really interesting to me, and I think to the membership at large. And then one thing I noticed that was kind of missing from the discussion, which hasn't happened in a long time, is materiality. We've finally gotten to a point in circuit courts where I think all of these courts are getting it right at this point. And they're understanding what materiality means. They're understanding that government payment is not dispositive of immateriality. And so I think we really didn't discuss materiality much for the first time since 2016. So that was something that I noticed that was kind of missing from the discussion, which I thought was a good thing because that means we don't have to talk about it anymore.
Yeah, one topic that was on everyone's concern radar was this kickback statute, the interplay between that and the False Claims Act, and the Eighth Circuit's decision that that we have to prove a but-for causation standard when it comes to these kickback cases. Can you talk about that and why that was the Cairns decision is wrongly decided, and why that was such a concern for people?
Sure. I mean, I think kickback cases, if there were to be if it were to be the law that you'd have to prove but for causation for each of these claims that was submitted as a result of kickbacks being paid, it would really be an impossible standard to meet for relators and their counsel, because you'd have to kind of get inside the mind of the doctors, and that's really not easy to do or possible sometimes, especially when we're talking about thousands of claims, having to prove that if not for this, hunting trip, these doctors would have prescribed some other drug. That is like a very, very impossible standard to meet. And it's not what the law is. So, I mean, the law was amended so that any claims that resulted from a kickback were false under the False Claims Act, and that resulting from does not mean but for, but that's how some of the courts are interpreting that. So yeah, it is a concern, and it's on our radar, and we're definitely going to see how we can kind of shape that going forward. But that's where we are right now. It's only 2 circuits that have decided it that way, and there's another case going up to the First Circuit. So we'll keep an eye out on that. But some courts that have held post Carnes that they disagreed with that, and that they were not going to follow that law or that interpretation of the law. And so I think that's a good sign that like some courts are understanding that that's just not actually the law.
So there was one topic at the conference that I found in the agenda and on people's minds that was kind of not part of the first 20-something years of this conference, and that's legitimate talk about trials, like cases going to trial. Why are some of these cases going to trial, especially in non-intervened cases? Why are we seeing the success of these cases going forward?
Well, I think just generally decline cases are going forward more. And I think that is because we as a bar have become more sophisticated. The government knows we're more sophisticated. Defense counsel knows we're more sophisticated. And I think especially that lends itself to the government saying, okay, I trust you. We don't have the resources to take on this case. We trust you, Relators Counsel, who we've worked with a whole bunch and we know are very, are great lawyers and very sophisticated minds. Go forward with this, and we're relying on you to take this case forward. I think that is happening a lot more, and I think that as cases continue to progress and the government just does not have the resources to handle it, we're more willing to step back and say, okay, are we willing to take this case forward if the government declines? And I think more of us are deciding we're not taking a case that we wouldn't take on our own forward. And so when the government's declining, we're almost encouraging them to decline at a certain point so that we can take the case forward, because we know that we can handle it. We know that the government knows that we can handle it, and we're ready to fight these cases out. And I think that I don't know that there's going to be a ton more trials, but I think the fact of the declined cases, it lends itself to there being more trials, just because the government's not there pushing settlement. And so I think if that's the case, and the defense counsel is willing to, I mean, they're paying their lawyers as we go, right? So if they're willing to fight that, then I think that there's just going to end up being more trials, and that's exciting. I mean, I think as was shown by this trial and others, juries understand this information. They know what fraud looks like. They can understand intent. And so juries are sophisticated as well. And so we're not afraid to take this to a jury. And it usually ends up pretty bad further up the other side when these cases do go to trial. So we're definitely not going to back down from that.
It reminds me, just a few days ago, Sam Bankman-Fried, founder, CEO, of this large cryptocurrency exchange, was found guilty on all charges. And I remember watching this going into trial, and the talk on the talking heads on TV is, this is such a complex case, and how are they going to find a jury to understand this? And I thought, in following the trial pretty closely, the federal prosecutors did a great job of saying, this is stealing. This is about fraud. And as these cases become seemingly more complex, it really is just a matter of stealing people's money, whether it's the government's money or money from the markets. And our job on the relator side, or representing whistleblowers, or the government side, is making sure that people don't get lost in the complexity of these financial transactions, that at the end of the day, when you reduce it to its simplest, it's stealing from somebody else. And I think that's what makes this area so interesting, that while there's a lot of change happening right now, and I talked about this at the conference during my talk, that we're in exponential times. As a matter of fact, I have this section of the Wall Street Journal, a whole section of the Wall Street Journal last week on artificial intelligence. That's like an exponential time right now, where things are changing so quickly. And, businesses are using all this exponential technology to grow and to reach further into the future and to make big advancements. But so are fraudsters, right? So when these technological advances happen, the good and the bad tends to follow. And our side, my challenge to the group when I gave my talk is that, exponential changes, we have a hard time understanding what that means. We think very linearly, right? If I walk 30 steps down the road, it's 30 meters. But if you take 30 exponential steps, where you double each step, you end up going around the world 26 times. So 30 exponential steps versus 30 linear steps. And oftentimes we find ourselves making these incremental changes, and we're fighting an exponential force. And, an example of this I give is, the Department of Justice adding a few line attorneys is an incremental change. But the Department of Justice leveraging the resources of our bar, where we're able to tap into resources and tap into whistleblowers who have infinite knowledge about what's happening behind corporate walls, that's an exponential change, where you can make an exponential impact as opposed to making a linear impact. And for us, recognizing that the changes that we're seeing on our side, being able to move these cases forward, going to trial, winning a trial, that makes a big difference on the calculus of the defendants, and saying, am I going to fight this, or am I actually going to settle this? Am I going to pay back the money that I stole? That has been one of the, I think, the biggest changes I've seen recently. It's that technology shouldn't be feared, but it should be recognized as something that's going to be used and abused by both sides. And we have to make sure that we put our resources and our challenges thinking big, not down the road 30 steps, but 30 exponential steps. So what are you seeing down the road? You're thinking about TAF in 2024 and beyond. Where do you think we're heading?
Well, so I think there's some trends generally that we've discussed in the practice. Again, decline cases going forward more, the AKS kind of battle that's happening. I'm curious to see what will happen with this decision in Polanski, in which Justice Thomas, in his dissent, questioned the constitutionality of the QTAM provisions. It's really interesting because when it first came out, I think we thought it was a very big deal, obviously, and we were we assumed, I think we assumed it was going to basically come up in every case. And I don't know if that's what's happening. And so I'm interested to see if it is going to be a big, blow up into a big deal that we're going to have to fight, or if it's going to be, something that people recognize is just not, it's just not going to be a successful argument because it's clear that these provisions are constitutional. So that's one, kind of going forward, what we might have to think about. I think there's also still been a increase in private equity, and I think that's going to continue to kind of change the atmosphere, especially in healthcare. And so I think that we'll have to continue to kind of focus on private equity companies that are coming in and buying out these practices. And then, as you just mentioned, I think in the practice itself, I think it's going to be interesting to see how AI and like ChatGPT and that stuff, like people are using that to write their briefs at times, and like, how that's impacting how the courts are looking at things, how judges are ruling, and how we're practicing, because there's definite, upsides, but there's also definite, drawbacks and cautions that we have to take. So I'm interested to see how that continues within the practice. As far as TAF Coalition itself, I think we're going to have this huge focus on financial frauds going forward. We have been ramping that up over the past couple of years, but I think it's going to be even more of a big deal going forward. I think more of our members and others practicing in this space are looking at these financial fraud whistleblower programs, and there's more coming out. There's the newer AML program, for instance. And as they continue to progress, I think we will see a shift in our members looking at those kinds of cases. I also think that we are really diversifying within TAF. So we have a diversity, equity, inclusion, and justice committee that's active, that we're going to continue to try to diversify our membership and also our client base. We now have a women's retreat that is going to be we had our first one last year. We're having another one this year. We have our whistleblower retreat where we're really trying to pull people into the fold. And so again, we've changed our name, to become a coalition. And I think that is, going to be amplified as we move forward, trying to bring people into our fold. And also just internally, we've hired a new attorney to work on projects here. We probably have a couple other hires this year. We're getting bigger because we have bigger ideas, bigger things to tackle. And I think that trend is going to continue, and we're going to grow, not just as, not just the membership, but also internally at TAF Coalition. So that's kind of where I see us.
Yeah, I 100% agree. We're seeing more and more people who are, I think, getting the phone calls from potential financial fraud whistleblowers, or they're getting the phone calls from people who think they have a False Claims Act case, and then they recognize that there's this component of the SEC or the CFTC being ripped off too. Oftentimes companies that are defrauding government programs are defrauding other programs as well. It's a business plan fraud that crosses jurisdictional lines. And you're absolutely right. It's interesting. We changed our name to the Anti-Fraud Coalition, and we've kind of grown into that name. We put the name out there maybe as aspirational, and more people have said, wait a second, I should be a part of this coalition. So certainly for those attorneys who find themselves as thinking about going into the False Claims Act qui tam world, or representing SEC or CFTC whistleblowers, we would encourage them to go to our website at taf.org and check out what we offer there. And for potential whistleblowers, we have a directory of whistleblower attorneys, and we're looking to expand the coalition to include other things that we'll talk about next year, perhaps on our next get together with Jackie. Jackie, is there anything else that you want to touch on before we wrap up today?
I don't think so. I think just generally we're going in a great direction. I think that there's lots of developments in the law, so stay tuned, and I'm sure I'll talk to you all soon.
Excellent. So until next time, if you see something, say something. When that doesn't work, it's time to do something.
If you believe you have witnessed fraud against the government or fraud on the financial markets, we encourage you to visit our website at taf.org, where you will find a directory of member attorneys who represent whistleblowers across the country. On our website, you will also find additional information about our nation's various whistleblower laws and programs and a way to donate to our organization as we step forward in spreading information about whistleblower programs. This episode was edited and produced by Rachel Brooks, and our theme song is by Connor Chaos. A big thank you to our TAF staff and researchers of James King, Emma Bass, Jacklyn DeMar, Kate Scanlon, Max Boldman. Fraud in America is a project of Taxpayers Against Fraud Education Fund. The opinions expressed on today's show belong solely to the guest and are not necessarily endorsed by the organization. Thank you for joining us on today's episode of Fraud in America.